Senate Bill 561 also specifies that a contract waiving either a homeowners association's responsibilities or a homeowner's rights under the Act is void as a matter of public policy. Current state law gives numerous protections to residents of common interest developments who fall behind on their homeowners association assessments and fees. Among other things, it requires that any payment made by a homeowner must be applied first to any outstanding assessment debt, not to the fees that have been accumulated, but to that actual debt. It allows a homeowner's payments to be applied towards outstanding fees and costs, including the cost of debt collection, but after the assessment debt is paid in full. These provisions are crucial. State law gives homeowners associations a powerful tool to use when assessments are unpaid. Homeowners associations are allowed to foreclose in non-judicial proceedings on a homeowner when the homeowner owes more than $1,800 in assessments at any time, or any amount of assessment that is due for more than 12 months, even if it's 1 cent. However, homeowners associations and third parties unfortunately have abused this power to foreclose by contracting with professional debt collectors who collect delinquent homeowner assessments and fees on their behalf. The companies often associated with law firms convince the homeowners to sign complex repayment contracts, explicitly waiving their rights under Davis-Sterling Common Interest Development Act, under the Davis-Sterling Act. The result of homeowners signing these contracts, making it that payments are applied first to collection of fees and only later to assessments, can be devastating. Because these payments are not applied to the balance of the assessment debt, a delinquent assessment is often owed for more than 12 months, even if the homeowner has been making payments. This balance triggers the homeowner's right to foreclose on the homeowner's property, the non-judicial disclosure which I referred to previously. These foreclosures are often based upon delinquent amounts that are extremely small, sometimes only a few $100s. In some cases, the debt collector even acts as trustee in the foreclosure proceeding. Foreclosures by these third-party debt collectors are much more common than you think. In 2008, there were 424 foreclosures in Alameda County alone. The opposition says that SB 561 will hurt homeowners associations. First of all, the only reason I think you would be able to make that argument is because it's based on a business model in which homeowners associations assign debts to third parties for collection, which is now a clear violation of current law. The other thing that is important to point out is that Senate Bill 561 actually expands the law and now will actually allow homeowners associations to sign contracts with third parties to collect their debts, as long as they follow the law governing homeowner associations and homeowners. I'm happy to accept the clarifying amendments in the analysis as author's amendments, and I just bring this to your attention as a very important and serious problem that needs to be stopped immediately. The legislature has repeatedly attempted to protect homeowners from these types of homeowners association abuses, and SB 561 will stop homeowners associations and debt collectors from circumventing the law. Here with me are a number of witnesses to testify in support of SB 561, including Marjorie Murray with the Center for California Homeowner Association Law, and Henny Kelly from the California Alliance of Retired Americans. Thank you, Henny. And Sylvia Curry, who lost her home because she was not allowed by a debt collection firm to pay off her assessments. We also, I think, have somebody here from the AARP as well. And thank you, members.
Okay, before we go to witnesses, we now have a quorum, so I'm going to ask the clerk to call the roll.
Evans?
Here.
Evans here. Harmon?
Here.
Harmon here. Blakesley? Corbett?
Here.
Corbett here. Leno?
Great. We are now operating as a committee, not a subcommittee. And to the witnesses, welcome. The committee does have a great deal of business before us this afternoon, so I'd appreciate it if you could keep your remarks to about 2 or 3 minutes in length.
We would be glad to do that, Senator Evans. I'm Marjorie Murray with the Center for California Homeowner Association Law, and we want to thank Senator Corbett for carrying SB 561. It's an important consumer protection measure. We are co-sponsors of the bill with the California Alliance for Retired Americans. Our message is very simple. There are state laws governing assessment collection, and under this bill, there would be clarification that the laws apply to any business doing assessment collection. The laws protect both homeowners and also the association, because it makes clear that when the homeowner makes a payment, that payment is to be applied to paying down the assessment debt. It is not to go to line the pockets of the debt collector. We also want to make plain who these debt collectors are. We're not talking about the people who collect dry cleaning bills or who collect the mechanics bills. This is a class of specialized debt collectors who are largely lawyers and subdivisions of law firms. What we do at our center is spend a lot of time trying to find lawyers in order to represent the homeowners who otherwise would be unrepresented in a duel with the law firm. One of the statements made by the opposition is that there may be some aberrant debt collectors who use these business practices. We have done actually a great deal of research into this question. These abusive practices are extremely widespread. Sentinel Fair Housing did research on this issue in 2004, presented it to the California legislature in public hearings, and as Senator Corbett just mentioned, additional research was done by the University of California, Davis in 2009, explaining the scope of these business practices and the number of notices of default that have been recorded against homeowner property. We might also ask, what is the purpose of these business practices? We know that it is not to collect assessments because, as our homeowner witness will explain, she made numerous attempts with cashier's checks, credit union payments, money orders to pay down the assessment debt, but the debt collector refused to accept the payments unless she signed their own payment plan, forcing her to waive her consumer protection rights under California law. The purpose of these predatory collection practices is actually to churn the account with collection charges. The Sentinel study and also the more recent study demonstrate that the average assessment amount owed is somewhere in the neighborhood of about $1,000, but the typical bill demanded by the debt collector is in the vicinity of about $5,000. The majority of it collection costs. So we urge the committee to vote aye on this measure. It's an important consumer protection bill. And I would like to introduce Ms. Sylvia Curry to my left, who will describe what it's like to be in the grip of an association debt collector.
Hi, I am Sylvia Curry. I have owned my Oakland condo for 30 years. The mortgage payment is paid off. I fell behind on my payments in 2007. On my own, I submitted a payment plan to the property manager, who said she would send it to the board for approval. Instead of sending it to the board for approval, the property manager sent my account to a debt collector, Association Lien Services, and got a referral fee for doing so. Association Lien Services sent me its own payment plan, demanding that I waive my legal rights regarding the application of my payment. Their profits first and my assessments last. This is against the law. They charge me for a lot of things. For example, 11 certified letters I never got. Some sent me a Daly City address where I have never lived. Their total bill to me was $5,853. The ALS payment plan also contains some kind of balloon payment at the end, though they refused to tell me what the dollar amount was going to be, though I asked them in writing. I sent multiple payments, cashier's checks, money orders, credit union payments, but ALS returned them saying they wouldn't accept them unless I agreed to the payment plan. I sought help from the county law library. My state assembly member, Sandra Swanson, and the Center for Homeowners Association Law, which finally found me a lawyer to fight off ALS. This was a 3-year nightmare. I felt like a prisoner going to jail for nothing.
Thank you very much for your testimony. Next witness.
My name is Henny Kelly. I'm the Legislative Director of the California Alliance for Retired Americans. We represent 900,000 retired Californians, many of whom live in homeowner associations, many of whom are like this lovely lady next to me. One of the things that bothers me the most is that she had already paid her mortgage. She didn't have a mortgage. All she had left was assessments, and she almost lost her house because of illegal practices. And that is something that I cannot believe should happen in the state of California. Foreclosures based on contracts that void homeowners' rights under the existing law should be void. Senate Bill 561 would make them void. Debt collectors should never act as a trustee in foreclosure proceedings. My husband's grandmother raised chickens. She's not letting a fox in the chicken house. But that's what these people are doing. This would make sure that debt collectors would not act as trustees. And no homeowner would be able to waive their legal rights, and neither would the homeowner association be allowed to waive legal rights. That's what's important about this law. You catch somebody when they are at their lowest and they are afraid they are going to be thrown out of their house, and you give them a sheet of paper and you tell them, if you don't sign this sheet of paper, nobody will help you. That is illegal in California. This law makes sure that it is illegal. It gives homeowners rights. It gives homeowner association rights too. It is a just law, and we would like to thank, on behalf of our 900,000 members, Senator Corbett for bringing this law to you today.
Next witness in support, please.
Randy Hicks with Californians with Disability Rights in strong support.
Ignacio Hernandez on behalf of the Consumer Federation of California in support, and also as an attorney who's previously helped individuals in this situation in support of the bill.
Thank you. Any other witnesses in support of the bill? Any witnesses in opposition? Please come forward. And again, for the opposition witnesses, we have a great deal of business before us this afternoon, so please limit your comments to 2 or 3 minutes. We would greatly appreciate it. Go ahead.
We'll greatly oblige. Madam Chair and a member of the committee, Ron Kingston, representing the Community Associations Institute. Just by way of background, the law that has been discussed today has been evolving for many years. It is unique, it's specific, it provides far more greater rights, disclosures, remedies than almost any other debt associated with the operation of a homeowner association or anything in connection with the home. Let me give you by way of example, and then we'll drill right down to the issues that the senator has presented. Nowhere else in the law is a homeowner have a right to a right of redemption except here in a non-judicial foreclosure proceeding. Nowhere else in law is there extensive meetings mandated imposed upon the homeowner association to the benefit of the homeowner. Nowhere else in law does the process specify certain disclosure proceedings and protect the homeowner. This bill is very unique. The bill seeks to, as the supporting witness and the author have suggested and stated, that it clarifies existing law. And in fact, it really doesn't clarify the law, it changes the law. And that's why we're here today. The change in law, first of all, will look at this. That we don't dispute that there have been abuses, but the abuse that was discussed today is not on point nor on message. And the reason is, if there was a charge for the performance of a duty that wasn't done, it's not eligible. The reason why the homeowner that was really seriously hurt by the homeowner association until it was remedied wouldn't have been helped by this law, or proposed bill, should I say. It was remedied due to existing law, existing practice, and interpretation, clarification. The process of homeowner association collection of delinquent debt is very, very important. Some homeowner associations choose to engage and offer, extend, if you will, the right to enter into this voluntary agreement by and between the association and the homeowner. And when that occurs, a payment plan is executed. Now, in the case of the unfortunate incident that happened, and we must all be sympathetic to it, empathize with it, and generally accept what was stated, in that case, the reason why it sounded like, to me, why the payments were not accepted was that no agreement had been reached on how to pay, when to pay, how much to pay. And we understand that a contract was necessary. But now, this bill does as follows, and this is the reason why our association, comprised of homeowner associations, is opposed to the measure. First of all, when the payment plan is entered into, it's between the homeowner and the board of directors. Boards, as you know, of which there are approximately 40,000 of them in the state, are voluntary, non-paid, don't have a car provided to them as a benefit program, and they're not experts in the field. When that happens, a lot of times when there are differences in turning over the debt to a third-party debt collector, it's not because they have to, in a sense, required by law, is because they need to. They don't want to involve themselves dealing with the next-door neighbor that's delinquent in the payment of debt. The reason why is maybe they're not able to or they refuse to. The association continues to provide all the services to the homeowner. Now, when they assign that debt, they have the debt collector, which is highly regulated in law, follow the law. The difference is that what they want to do is to say the contract, whatever was entered into between the homeowner and the homeowner association, has to be followed, can't be changed. But the issue then becomes only one: who pays the collection costs? It was suggested by the committee analysis that ultimately it has to be paid. That's absolutely true, but they have to be paid ultimately. It's either the homeowner or all the rest of the homeowners, because many payment plans, you find there's default and the homeowner association has to pursue another form of debt collection. So in a sense, this will frustrate all those payment plans that do not and cannot fully be executed. So the homeowner association, ultimately the responsible homeowners that do pay their assessments, will pay for this debt. We don't believe that that's fair at all. It's not right. The person who incurs the cost should be obligated to pay for it. And the homeowner association, on the second part, will be very disenchanted, actually discouraged from actually entering into a payment plan, because they know, for the most part, a homeowner will not be able to pay for the collection costs, and then it will fall on them. Why enter into something is if they're not guaranteed payment. It was
I'm going to need you to wrap it up.
Okay, thank you. This is, we are not suggesting, as the proponents suggest, lining the pockets of the debt collector. That has nothing to do with it. It just, whatever their fees and charges are, can be lawfully remedied. If you want to talk about that, that's not this bill. So, in sum, what we suggest, Ms. Evans, is that we have to have some type of remedy that assures the debt collection company to be paid. This bill doesn't do that. So then, therefore, this bill forces us to pay that debt. And that's not the way a bill should be fashioned to collect delinquent debt.
Thank you.
Madam Chair, thank you. Cliff Berg here on behalf of the California Association of Collectors, which is the organization which represents approximately 400 collection agencies in California. I think some of the heated rhetoric behind the proponents of this bill sort of speaks to the concerns that we have, stepping back and stepping away from some of the rhetoric that you heard. In essence, the whole purpose of a collection agency's involvement in what is a fairly sensitive relationship between a homeowner association and homeowners, which are obviously intertwined, is to try to work out for the benefit of the homeowners association and the homeowner a payment plan and a way of resolving a delinquency in payment that avoids foreclosure. Most of the time, a collection agency is hired by a homeowners association because the homeowners association themselves are scarce in resources and do not have the resource capacity to manage their accounts receivable. It's interesting to note that collection agencies, a huge part of their work is simply managing accounts receivable. And rhetoric which goes to like lining collection agencies' pockets is really not constructive for either homeowners associations or homeowners. Homeowners associations and homeowners need a neutral third party who can manage accounts receivable in a professional manner and ensure that, in essence, fees are collected, dues are paid, and that's kept track of. No different than lawyers, accountants, and a collection agency is a highly regulated profession subject to the Fair Debt Collection Practices Act. And what they do is, in essence, try to work out problems for the benefit of both parties and get the situation resolved. In reality, yes, they have to be paid by somebody, just like an attorney, just like an accountant, just like a doctor. The notion of that the fee for their services to work out the financial management of these associations is lining pockets is just, I think, a problem with the intent of the sponsors on this bill. And we would urge your no vote because this bill intervenes in a relationship that's best left between the homeowners association and the homeowners. Homeowners are members of the association. They need to figure out the way in which the collection agency is paid to manage the accounts receivable in a manner that meets the needs of the association. And to have legislation that seeks to regulate the way in which that relationship is managed, I think, oversteps and will be counterproductive. And the end result, if this legislation is currently drafted, will be more foreclosures because of failure to work out the financial issues involved. So, we think this bill overreaches. It's well intended, but it would have a negative impact on both homeowners associations and homeowners, and therefore respectfully oppose the bill in its current form. Thank you.
Thank you. Ms. Mazzoni. Sure. Mr. Berg. Mr. Harmon has a question.
A brief question. If this bill became law, Mr. Berg, would it become difficult or almost impossible for collection agencies to get paid in this situation?
That's what my members tell me, correct.
Thank you.
May I answer that question? I don't think we've discussed the many other remedies that are allowed to collect these unpaid debts. Foreclosure should not be the only answer to collect. There are plenty of various ways people can collect these debts.
Okay. Other witnesses in opposition?
Thank you, Madam Chair and members. Carrie Mazzoni for the Executive Council of Homeowners for the reasons already stated in opposition to the bill. Thank you.
Thank you. Any other witnesses in opposition to the bill? Questions, comments from the committee members? Senator Corbett, you may close.
Thank you very much. First of all, sometimes in these discussions we can get a little heated. So I do want to apologize if there's any inference that that debt collectors are not, for the most part, well-meaning people doing important jobs. But the fact of the matter is this is a serious issue. People's homes are being foreclosed upon. Even people who don't owe one more cent on their mortgage simply because they've found themselves in a situation where they have tried to pay a past due assessment and have not been able to, or have not, because of the terms, or have not been willing to agree to terms of a contract of repayment which waives their rights under state law. And the bill does, of course, take into consideration this concern that was expressed by some of the opposition, that obviously it is true that sometimes these organizations are run by volunteers. But we have actually, in this bill, expanded the law to allow homeowners associations to make it clear that they can contract with debt collectors to do the debt collection. But the important key factor is to preserve the rights under Davis Sterling to allow people to first have their assessment paid and then pay the other debt. And there are plenty of other remedies for the collection of that other debt. And the reason that this is so important is homeowners associations do have the right under the law to non-judicial foreclosure. So unfortunately, this practice in some cases has been abused and people have lost their homes, and we're just trying to make it clear that individuals do have rights under Davis Sterling to be protected from losing their homes.
Thank you. I do want to note that Senator Leno has joined us. Welcome. Did you? Okay, we have a motion, and I just want to mention interesting debate from both sides, and I think good points were made, but I also think that this bill addresses a very real problem. The foreclosure option is one that should be only resorted to when everything else fails, obviously. And those that are collecting on the debt that is owed should have no greater rights than the homeowners association, and I believe that this bill addresses what might be called a loophole in existing law. So I will support it. We have a motion. Call the roll.
The motion is to pass as amended to the Senate floor. Evans?
Aye.
Evans, aye. Harmon? Harmon, no. Blakesley? Corbett?
Aye.
Corbett, aye. Leno?
Aye.
Leno?
Okay, 3-1, and we will put the bill on call for the absent member.
Thank you very much, members.
And
Madam Chair.
Senator Corbett, you have a second bill, item number 9, SB 684.
Thank you, Madam Chair. Thought you might have some other authors out there in the audience.
I
but
thought I would too, but I'm not seeing anybody. If there's another author that could step forward at this time.
Okay, very good.
Not seeing one. Go ahead, Ms. Corbett.
I'm glad to move forward. I'm here now presenting Senate Bill 684. Members, California's workers' compensation law was passed by the state legislature in 1913. Workers' compensation insurance policies are highly regulated and designed primarily to protect the worker and ensure prompt payment of claims. Later disputes about the payment of these claims are often handled through arbitration instead of litigation. Because virtually every working Californian is covered by workers' compensation insurance, it is important that employers and employees have a mutual understanding of how and where any disputes about workers' compensation insurance are resolved. Some workers' compensation carriers issue unapproved side agreements separate from their policies, which require arbitration disputes to be handled in a state outside of California, even though the employee and the employer are in California. This requires the employer to travel to another state in order to arbitrate a dispute with their workers' compensation carrier. Senate Bill 684 requires that when a workers' insurance policy is issued to a California business to address how disputes between the employer and the workers' compensation insurer are resolved, the provision must be included in the original policy. The policy is then filed with and approved by the California Department of Insurance and must be provided to the employer concurrently with any written quote for insurance coverage. It can't be attached to the policy later. Senate Bill 684 requires that any disputes between a California business and a workers' compensation provider that issues insurance coverage to a California worker who is injured in California must be resolved under California law. However, both parties may freely negotiate the venue of choice. Senate Bill 684 assures that when a California state agency has been granted the authority to resolve the dispute, it would not be subject to an alternative dispute resolution between an employer and workers' compensation carrier. This bill is supported by the Department of Insurance, and here to testify in support is Deputy Commissioner Michael Martinez. Chris Sitko, an attorney with the Department of Insurance who specializes in workers' compensation, is also with us, and Mike Adriani with Roxborough, Pomerantz, Nye, and Adriani. I respectfully ask for your aye vote.
Thank you. And again, to the witnesses, the committee has a great deal of business before us today, so if you could try to limit your comments to 2 to 3 minutes, we would greatly appreciate it. Go ahead.
Absolutely. Thank you, Chair Evans, Michael Martinez, and Senator Leno, and Senator Smidian. Michael Martinez here on behalf of the Department of Insurance, here in strong support of this measure, SB 684, before the committee today. And it's a pleasure to be here. This is a bill that's very similar to Assembly Bill 2490, which was authored by then Assemblyman Dave Jones last session. We believe SB 684 is necessary. It is appropriate and fair to California's employers and businesses. It does, very similar to what Senator Corbett had said, it does address a few major issues. Firstly, it does, despite current state law that requires workers' comp policies be filed with the insurance commissioner, some of these workers' comp carriers issue these unreviewed, unapproved, and unfiled separate collateral agreements or side agreements. And we believe this bill is necessary in order to mandate that these side agreements be filed with the insurance commissioner today, which is in line with what current state law mandates. Secondly, SB 684 allows employers and insurers to freely negotiate and mutually agree to a choice of forum other than California to arbitrate. However, we believe that California policies for California-based businesses approved by the California Department of Insurance should be held subject to California law. We believe each state does have its own unique workers' comp laws, so this piece of the bill is very critical. We believe that purchasing a policy that adheres to California laws and then subject them to another state's laws to benefit one side is simply wrong. Lastly and thirdly, we believe that it's necessary to ensure that SB 684 preserves existing state law regarding plenary authority. The state legislature is granted plenary power over the state's workers' comp system. The clearest example of another entity that has authority to resolve injured worker benefit disputes is the Workers' Compensation Appeals Board. And so we want ability to have to retain this authority that's also given to the insurance commissioner under specified conditions. So that being said, we respectfully ask for your aye vote. Again, I have Chris Sitko here to answer any questions that you have. Thank you.
Next witness.
My name is Michael Adriani. I'm a partner at the firm of Roxborough, Pomerantz, Nye, and Adriani. My firm specializes in representing employers, California employers, typically in disputes with their workers' compensation insurance carriers. So we deal with these types of issues all the time. In fact, we were the law firm representing the Ceradyne company in the case mentioned several times in the notes. So I kind of have my boots on the ground on these issues. I see them play out all the time, and I can tell the committee that it is quite common for a California employer to enter into a policy of workers' compensation insurance, pay the premium, and only months later discover that there's this, or be provided this side agreement that has not in fact been filed with the Department of Insurance. And the side agreement contains provisions that call for any dispute, any dispute whatsoever to be handled in another state, under another state's laws. And I've seen these things play out over and over and over again. We have, in fact, had to arbitrate cases using Connecticut law, for example, for some carriers, using Illinois law, Florida law, New York law, all disputes revolving around California workers' compensation insurance policies. I can go into as much detail and answer whatever questions, but I do have my boots on the ground on this issue. I've seen it play out, and it is a real issue for California employers, an expensive one as well. Thank you.
Got it. Thank you. Any other witnesses in support of the bill? Witnesses in opposition to the bill? Please come up. And if we could perhaps clear a little bit of, maybe one of you can stay here to support the author and the rest. Push the red button there and then start with your name and affiliation, if any.
Can you hear me, Madam Chair? Members of the committee, Lee Sandahl with the International Longshore and Warehouse Union, and we're in strong support of this legislation.
Great, thank you. Any other witnesses in support before we start with the opposition? All right, witnesses in opposition. And again, if you could, do your best to confine yourself to 2 to 3 minutes since we have a lot of business to transact this afternoon.
That's our specialty, actually.
Perfect.
Madam Chair, woman, members, Theo Pejos, representing the Association of California Insurance Companies. We know that this is early in the process, and this bill will have some way to go. But we'd just like to note that there are probably things that reasonable people would agree should be adjudicated in California jurisdiction. However, there are a set of things that I think reasonable people would agree should not be adjudicated in a California setting. So this bill doesn't really adequately separate or make a differentiation between the two. We do note the flexibility in the bill, but for instance, if you had a dispute over the administration of a benefit, that of course has some uniqueness to California law, and the employer was based in California, that would be one set of circumstances. If you're talking about a collateral agreement or a letter of credit from a financial institution whose involvement was part and parcel of the policy, that was maybe headquartered somewhere else or had, as part of their boilerplate language on dispute resolution, had other jurisdictions, that's another set entirely, and we wouldn't think that would be appropriate to include in this bill. So it is a little bit too wide in terms of how it approaches all types of resolution dispute provisions. They're not just in the policy that's in questions, but there are other parties involved, and there could be all kinds of different agreements that doesn't necessarily have anything to do with California law. The other point I'll make real quickly is I think we need to be careful when we talk about a California employer. If you're talking about an Apple or another company that's based in California, maybe in San Francisco, versus a multi-state employer that has just a nominal presence here and is negotiating one of these very complex, high-deductible policies for a number of employees over a number of different jurisdictions, that I think again would be a too broad of an inclusion. So we believe that there's some substantial narrowing that has to take place in the bill, and for those reasons we're opposed. Thank you.
Thank you very much. Yes.
Steve Suchel, American Insurance Association. We're also opposed to the bill. Basically, what we're talking about here is contracts that are large commercial accounts, and the negotiation of which involve risk managers, lawyers, and very, very complex multi-state agreements. To use such a broad swath to cut across these things really goes against what these are. And also, very often, under current law, these agreements, these insurance policy agreements, and the policies themselves are very often custom-made and need not be filed with the department because it's an employer-by-employer negotiation. Lastly, I'd like to point out that the Ceradyne case, which is mentioned several times, was an unpublished case and had a very difficult set of facts, which basically, where both parties didn't discover that there was an arbitration agreement until sometime after the litigation had commenced. And also there was a dispute about whether to bring the litigation in California and in New York. So the Ceradyne case is unpublished and really is an example of a very unique and narrow set of facts. And lastly, I'd like to point out the provision of the bill which basically overrides arbitration agreements made by employers and insurers where a state agency has the authority to make determinations is very difficult. Basically, what that does is it overrides legitimate policy decision, negotiation, and commercial decision by two parties in every situation, and that really is reaching way too deeply. Thank you.
Catherine Pettibone with the Civil Justice Association. We have an oppose and less amend on the bill. We thought the previous version struck a balance between allowing parties to contract but still providing some certainty in the law and would have addressed the Ceradyne case concerns. Thank you.
Thank you. Any other witnesses in opposition to the bill? Questions, comments by committee members? Mr. Leno.
Thank you, Madam Chair. I'm looking at the governor's veto message of Assemblyman Jones's bill, and having familiar experiences with Governor Schwarzenegger's veto messages, not, well, let me say, always most informed.
He didn't sign all your bills?
You know, it's not so much the signing or the not signing. It was the message that went along with it. Oftentimes, it wasn't really associated with anything in the bill. He starts off by saying that there's no evidence to demonstrate the problem exists. I think that your proponent's testimony deals with that, but then also goes on to express concern that the potential for costly regulatory interpretation that could impact the cost of workers' compensation insurance. I wonder if you could address that, just with this bill as law. The concern, if not threat,
Yes.
is that workers' compensation rates are going to soar.
Yes, Mr. Sitko is the expert on this issue, and I'll allow him to answer that question.
Yes, I would think that there would be very little additional cost on the system in doing this already.
Could you first state your name and affiliation?
Christopher Sitko, Senior Staff Counsel with the Department of Insurance.
Thank you.
Sorry about that. Already, there's a requirement that any obligations on the insurer or the insured need to be filed with the department. This should not add any additional cost in the system itself. The system is based on the benefits that are paid out to injured workers. What we're talking about is how are disputes going to be resolved between the insurer and the insured. And that, other than requiring that they be in California, unless otherwise agreed, and applying California law, we don't envision any costs related to that.
That's what I would have thought. And then just one other point that was brought up by the opposition. Is there any need to better clarify an employer's principal place of business? There was concern about businesses that operate multinationally or in many states throughout the country. Is the definition fairly clear in the bill? Yes. Senator
Leno, that was a question that was also raised by Senator Harmon's office, called my office and asked about that. The intent of the bill is that it apply in situations where the employer is a business in California, not a multi-state entity. Mr. Payos referred to that sort of situation. But this bill is intended to be much narrower to apply to a California business doing business in California for an injury in California. And we would be glad to work with everybody involved to ensure that the intent of the bill, the language of the bill matches with the intent of the bill, and the Department of Insurance might have a further comment on that.
So as mentioned in testimony, the multinational that happens to have an office here or a small outpost here, that's not what
it would not apply to them.
Yeah, the intent of the bill is to deal with the issues that were previously testified to about the California employer who is working out one of these agreements with an insurer, and typically the insurer is in another state, and the insurer is providing an agreement which imposes on them typically the domicile of the insurer, a favorable forum, and favorable law, too. And we're asking that if it's a California employer, that it occur in California. The fact is, many employers are multi-state employers. They're very sophisticated, and they are able to figure out where they would like to be if they're involved in many states, and we're not trying to interfere with that.
Very good. Thank you. And I would move the bill.
Okay, we have a motion, and I just want to mention that as a lawyer for a couple of decades, longer than I'd like to remember, I was involved in a lot of insurance coverage disputes, and often I read more insurance policies than I like to remember. But often just determining what the applicable law is the subject of vast litigation and appellate procedures and huge bodies of law, and it's very challenging, particularly when you are a small business and your principal place of business is in the state of California, and we're talking about this bill applying to those kinds of businesses which are primarily smaller in size, that have been mandated by California law to purchase workers' compensation insurance to cover their employees that are operating in the state of California. So this makes a lot of sense, and actually I think it's a good small business measure, so I will support it. We have a motion. Would you like to close, Senator Corbett?
I just ask for your aye vote. Glad to work on this issue of clarity if necessary. It's common sense. You're injured in California. Your employer is in California. California law should be applied.
Thank you. Clerk will call the roll on the bill.
The motion is to pass to Senate Appropriations Committee. Evans?
Aye.
Evans, aye. Harmon? Blakesley? Corbett?
Aye.
Corbett, aye. Leno?
Aye.
Leno, aye.
All right, it's 3-0, and we will keep the measure on call for the absent member.
Thank you, Madam Chair and
Senator Keogh,
members.
you are next, and thank you very much for your patience. So we will take up item number 2, SB 116.
117.
Excuse me, item 117.
Thank you, Madam Chair. Where would you like me to start? 117? Oh, right.
Yes, please.
This is on public contracts. And members, if I could give you a brief background. In 2003, I authored AB 17 that was signed into law. It prohibited state agencies from entering into a contract of $100,000 or more with businesses that discriminated against registered domestic partners in providing employment benefits. This bill, SB 117, updates that law by prohibiting state agencies from entering into contracts of $100,000 or more with businesses that discriminate against legally married same-sex partners. So this bill protects the 18,000 same-sex couples that were legally married in California prior to the passage of Proposition 8, and also those who are legally married in other states. This bill encourages fairness in the workplace. A significant portion of every employee's remuneration comes in the form of benefits, such as health benefits, of course, bereavement leave, moving expenses, pension, and retirement. Providing these benefits to employees with spouses and registered domestic partners, but not to legally recognized same-sex married couples would be unfair and discriminatory. The bill levels the playing field to make sure all businesses are at a level playing field, that no one is at a competitive disadvantage. It enables businesses to attract and retain employees, lowers recruitment and turnover costs, and helps improve workforce diversity. It's based on a simple premise that if taxpayer dollars are going to be spent by state agencies to contract for goods and services, then those tax dollars should not be spent in a discriminatory fashion. It is sponsored by Equality California. The bill has support from the California Nurses Association, the Commission on the Status of Women, Gray Panthers, Employment Lawyers of California, and the Labor Federation, among others. And I have Matt Bunch with me from Equality California. I ask for your aye vote.
Thank you. Witnesses in support. And again, if you could do your best to limit yourself to 2 to 3 minutes, we would greatly appreciate it because of the press of business. Thank you.
I'm Matt Bunch. I'm here on behalf of Equality California. SB 117 would simply update existing law to prohibit the state from contracting with businesses that discriminate against legally married same-sex couples, including the tens of thousands of couples who are legally married here and elsewhere. It's a very small update to existing law. Providing the same benefits to an employee with a domestic partner or same-sex or opposite-sex spouse ensures that workers receive equal pay for equal work. To do otherwise is essentially to discriminate against gay, lesbian, bisexual, and transgender employees. Treating employees fairly is a sound business practice. A non-discriminatory benefits program enables employers to attract and retain the best and most talented employees, lowers turnover and recruitment costs, and helps to improve employee job satisfaction and performance. For this reason, Equality California is proud to sponsor this bill, and we ask for your aye vote.
Thank you. Next witness.
Madam Chairwoman and members, Francisco Labac on behalf of the American Civil Liberties Union. We come up here to express our support for the legislation, clarifies that same-sex couples are equally protected. We think it's a good bill. We urge your support.
Beth McGovern on behalf of the California Commission on the Status of Women, also in strong support.
Mariko Yoshihara with the California Employment Lawyers Association in support.
Kelly Green with the California Nurses Association in support.
All right. Any other witnesses in support of the bill? Right?
Okay. Thank you, Madam Chair, members of the committee. For the record, Mitch Seaman with the California Labor Federation in strong support.
Thank you. Other witnesses in support of the bill? Any witnesses in opposition? Questions or comments from the committee members? Mr. Leno?
Thank you, Madam Chair. Just briefly, I'm really pleased to see that there are no voices of opposition.
Yes.
We've come a long ways. I may have my history off just by a bit, but I think it was the city of Berkeley and/or West Hollywood that first provided equal benefits for equal work. It was an unheard of idea not too many years ago. And San Francisco was the first larger city to do so, and it really began to change the way business is conducted. In fact, now in the 21st century, there's probably a majority of Fortune 500 companies who do provide equal benefits, with more corporations joining every month. So it's a statement in itself that we can make this slight adjustment to current law. Thank you, Senator Kehoe, for bringing this forward, and I'm happy to move the bill.
Thank you, Mr. Leno. And I did want to mention this is one small step forward towards equal application of California law to everyone. I appreciate the bill.
Thank you, Madam Chair. Thank you,
We have
Senator
a
Leno.
motion. Would you like to close?
I would ask for your aye vote.
All right. Clerk will call the roll.
The motion is due pass to the Senate floor. Evans?
Aye.
Evans, aye. Harmon? Blakesley? Corbett? Aye. Corbett, aye. Leno?
Aye.
Leno, aye.
The bill has 3 votes to 0, and we will keep the bill on call for the absent members.
Thank you, Madam Chair.
Thank you, Senator. Would you like to go now to item number 5, SB 337?
I would indeed. Thank you. First of all, Madam Chair, there's some suggested amendments in the analysis. I'd like to adopt them at this time. Bottom of page 6, amendments clarify that renters of common interest developments have the same rights to free speech as the owners of common interest developments. And on the last page of the analysis, page 9, it deletes subsection B on page 2 of the bill. Thank you. Thank you, Madam Chair. And if I can again just point out that a similar, though narrower bill was passed by the legislature and vetoed last year? 2005. Oh, well, we're getting all kinds of numbers, but recently. Anyway, so we want to address this issue again. This bill clarifies existing law by affirming that tenants at multifamily and single-family dwellings have all the same rights of free speech as property owners. That is that they have the right to display non-commercial signs, posters, banners, or flags. It's our First Amendment rights to free speech. Every school child knows that, and it should be extended to everyone, not based on the kind of housing you enjoy. Almost 40% of our state's population live in rented homes. That's approximately 16 million Californians who, by virtue of their property status, are not under current law allowed to freely express themselves at their own homes. What you may not know is under existing law, there are protections for tenants being retaliated against by their landlord for exercising various rights under the law. But it is not clear that free speech is protected. That is, that tenants may not be protected from landlord interference if they are exercising their right of expression via political sign, flying the flag, or other kinds of displays. This is on their property. While we hear stories about these problems, this bill will make it clear that a tenant has a right to post a sign, banner, or flag, so long as it does not violate local ordinances or state or federal law for that matter. While none of these forms of expression are illegal, the duration of a sign, how long it may be posted, or even the size can still be regulated under local ordinances. It does nothing to limit local ordinances on these matters or on safety issues, but it will allow renters in apartments or common interest developments to display signs, posters, and flags. The bill is sponsored by the ACLU. It's supported by the California Congress of Seniors. And with me today is Francisco Labaco of the ACLU. Again, I ask for your aye vote.
Madam Chairwoman, members, Francisco Labaco on behalf of the ACLU. Senator Kehoe laid out the justification for the legislation very well. It's intended to clarify and support the free speech rights of tenants. Over the years, our 3 offices get calls from tenants who are threatened with eviction because they want to post political signs. One of the most recent examples was a situation in San Diego where a tenant wanted to post a pro Prop 19 sign. What we tell them is that it's in our view that existing law 1942.5 was always intended to protect tenants who want to post political signs, and the Supreme Court, and we argue that the California Constitution arguably protects the tenants, but I think it's clear that there's nothing in statute specifically protecting the rights of tenants. And that's what this bill tries to do. It extends very similar protections to tenants that exist in common interest developments. Legislation passed a few years ago by Assemblymember Longville. And as Senator Kehoe indicates, up to 40% of the households in California are, in fact, tenants. And the fact that folks who don't have the resources to live in a condo or on a townhouse should not mean that he or she has less protection to engage in a long-standing traditional means of expression. As the Senator indicates, the bill makes clear that local ordinances apply in terms of that can't violate any local ordinances. Your committee analysis makes reference to some of the arguments of the opposition in terms of the type of signs that would be posted. Similar arguments were made when Mr. Longville introduced the legislation with respect to the CIDs. Nothing has come of it. We think it's a good bill, it's a straightforward bill, and we strongly urge your support. Thank you.
All right, thank you very much. Other witnesses in support?
Just quickly, Madam Chair, Skip Dawn for the Community Associations Institute. We very much appreciate the author's acceptance of the committee's suggested analysis, and we withdraw our opposition.
How nice.
How about that?
Thank you. Yes.
Mike Montgomery with the Congress of California Seniors. As the Senator mentioned, we do support SB 337.
Great, thank you. Any other witnesses in support of the bill? Witnesses in opposition? Yeah.
Our favorite topic. I'm glad you didn't wear your Obama button.
Good afternoon, members. My name is Deborah Carlton with the California Apartment Association. First, I want to thank the author for removing Section B from the bill. And we want to actually just reiterate some of our comments in our letters in that we really believe that landlords are in a unique situation, different than what we would argue mobile home parks and or homeowner associations are. Of course, we're obviously always trying to balance the rights of tenants and the quiet enjoyment. We have a legal duty to balance that in apartments. Now, we were able to find some common ground with the Senator on our previous legislation involving political signs. We'd like to work towards that direction if we could. The same thing that we also see in homeowner associations. There are specific regulations that are laid out in the current law, and we would like to work towards at least some sort of understanding about the regulations that have always been placed, at least are in place in the current statute as it relates to homeowner associations. So with that, we still would request a no vote unless we can find some common ground. Thank you.
Madam Chair and members, Steve Carlson for the Apartment Associations of Greater Los Angeles, San Diego County, and Santa Barbara. Similar concerns to Ms. Carlton. I would like to point to the Governor Schwarzenegger's veto message of SB 540, which I think was 2006, Senator, as I recall. I think it was 205, 206, which said that the bill offered no clarity on the rights of property owners to control the appearance of their property and protect the environment for other tenants. And a landlord, property manager, has a specific set of responsibilities to maintain a situation that doesn't exist in a homeowners association, doesn't exist really in a mobile home park situation where most people are owners. This is an instance where even though local ordinances might apply, the local ordinances are all over the map with respect to signs, and unless they're and they may not work with the type of apartment, the size of apartment, the size of the units, and those sorts of things. So to have as open-ended an approach as this, we think creates some problems. We also am not sure that there is a problem to be solved here. I don't think owners are running around saying you cannot post anything. I think people put put their college signs up when there's a bowl game and that kind of thing. I don't think people care about those issues. Then there are signs that are a tad bit more controversial, and some people might find them offensive, others might not, and that might create some issues as between the tenants. And so there has to be some balance on this, and unfortunately the bill at this point we don't think strikes that balance. We would like to work toward a better balance, but we'll have to oppose the bill in its current form.
Madam Chair, members, John Smock representing the Apartment Association of Orange County. We concur with the remarks previously made. Let me add just two very quick items. We suspect that it would be the city and county involved that would be charged with the enforcement of a local ordinance, in which case the owner would be cited and have absolutely no opportunity to correct because they have no responsibility with respect to the tenant under this bill. So the owner would be charged with a violation, have to pay a citation and attorney's fees to defend, but it would be the owner who bears the burden of a tenant's violation of a local ordinance. So we're very much concerned about that, and I think, as Mr. Carlson says, reasonable tenants expect reasonable rules and regulations. This would be a measure that is a blunderbuss, if you will, a one-way street for tenants, particularly obstreperous tenants, to push the envelope. We're very much opposed to the bill in its current form.
Madam Chair, members of the committee, Ron Kingston representing the Apartment Association of California Southern Cities and the San Francisco Association of Realtors. We too are opposed to the measure and offer substantially different reasons for opposition. The proponents have argued that this is a free speech right. If that is true, this bill is not needed. For those who believe that it is not a free speech right, this bill overreaches, has the strong possibility of causing tremendous friction among tenants. Let me give you one example that just happened in Sacramento. Two different housing units side by side. One posts a sign of a swastika. Nobody would rent the house next door. Nobody. And it went on and on and on, and ultimately resulted in a temporary restraining order against the homeowner that posted the swastika. The other owner just couldn't rent his property. That is particularly problematic for us. Next is that Mr. Spock talked about government, but here's the real situation in this and practical implication of this bill. And that is, imagine a recalcitrant tenant putting up an objectionable sign. Let's say it is a swastika. Who can enforce that? The property owner is not going to be able to enforce that because only government can make that determination if it violates local, state, or federal law. It is not vested with the landlord. This bill doesn't create that right, nor do we want to be the sign cops for local government to make that type of determination. As a result, government that is called in to do that will be really reluctant in doing this in today's economic times. It will cause substantial disruption for local government to come in there. They won't want to do it, and in the case that they rarely do it, then we will be the ones that cite it and will not be able to pass that type of cost and enforcement to the recalcitrant tenant. For these reasons and many others, we respectfully ask your no vote.
Thank you. Any other witnesses in opposition to the bill? Senator Keogh, a couple of questions raised during the testimony that I wanted to ask you about. First of all, I want to say the bill addresses an issue that's a long-standing concern that I've always had, which is the regulation of free speech, particularly political, non-commercial speech, in a common interest development. And I know that some are more restrictive than others, but this, having served in local government, this is an issue that comes up quite often. And I know that you're trying to allow for free speech, but then there are other issues that come up. And for example, one of the questions I wanted to raise was the issue raised by Mr. Kingston, where one of the tenants or one of the residents may post something that, while it is covered by the First Amendment and it is allowed speech, could be perceived by some as somewhat threatening, such as a swastika, or somehow offensive. And while the person has the right under the First Amendment to make that speech or engage in that speech, it also infringes upon the owner's right to rent an adjacent apartment or something like that. So how would you address that issue? It's kind of a gray area.
I would like our sponsor to jump in here.
Madam Chairwoman, it's a very good question. Of course, free speech, the way this bill is drafted, free speech rights are guaranteed to the tenants as long as it's not obscene, threatening. So to the extent a particular message constitutes a threat or either a criminal threat or fighting words or otherwise illegal under the law, nothing would prohibit a landlord from evicting the tenant for the content of the sign, as long as the content of the sign was otherwise illegal. So, we heard the same kind of arguments in terms of the CID scenarios, which are a lot of condominiums and which are very close together and the like. I'm not saying it can't happen. A lot of people live in this state, but it's a bit of a red herring, even though I think the way the senator has drafted the bill, it should protect those kind of situations to the extent that we need to, work it a little more. I'm sure the senator would be more than happy to do that.
Yeah, I think it is something you might want to look at as you move forward. Did you have something to add, Senator?
Just a brief comment, Madam Chair. That I remember that swastika story because it was covered in the Bee over a long period of time, and even though I'm a semi-out-of-towner, I was aware of the issue, and having been on a city council, there are times when these things come up. To be candid, I don't think the bill can address the most extreme cases that are going to wind up going to court or maybe even higher up in the courts. But remember, for millions of Californians that simply rent an apartment or a unit, being able to put out a campaign sign or a team sign is something that I think should be clarified in law and make sure that they know, and their neighbors and their landlord know, that they're able to do that. And that's what the bill is aiming for.
And I think that is a worthy goal and an important one. But I do agree that there are times when...
We'll continue to work with all of our the stakeholders, and we are listening. We've been down this road before.
Yeah. It's just those, and it does happen that people take things a little too far, and it is perceived as threatening to others. So that's just one gray area to be potentially addressed as it moves forward. The other one is a question. The question was raised, or the issue was raised, that the owners believe they would be cited by the local governance, whether it's the city or the county, for violation of the local ordinances, the local sign ordinances. As I read the bill, the landlord or the owner would not be cited. It would be the tenant that could potentially be cited for violating the sign ordinance.
Excuse me, and the way it's intended is that if in fact the tenant posted a sign that otherwise violated the local ordinance, the landlord would totally within his or her right to evict the tenant in violation of the law.
Right, so the landlord can evict the tenant, but if there's any citation involved, the way I read it, the citation would be addressed to the tenant, the person posting the sign that's in violation of the ordinance.
That's the way I would understand the statute should work, yes.
Right, that's the way I read it.
I think the committee amendments on the bottom of page 6 kind of emphasize that. It doesn't specifically address citation, but it does say violations of local, state, federal lawful provisions in a common interest development, and covenants, conditions, and restrictions. Those are all mentioned in the amendments I just took.
Right. Okay. Any other questions? Then I will entertain a motion on the bill. Thank you. Call the roll. Oh, excuse me. Senator Keogh, would you like to close?
I would ask for an aye vote.
Thank you.
The motion is to pass as amended to the Senate floor. Evans?
Aye.
Evans, aye. Harmon? Blakesley? Blakesley, no. Corbett?
Aye.
Corbett, aye. Leno? Leno, aye.
3-1, the bill will remain on call for the absent member.
Thank you, Madam Chair.
Thank you.
Mr. Leno, Senator Corbett, thank you.
Mr. Rubio, you are next. And that is item 7 on our agenda, SB 484. Senator Rubio?
Thank you, Madam Chair. Colleagues, SB 484 would increase the transparency of prison health contracts by allowing the Legislative Analyst's Office and members of the California State Legislature to inspect a health care contract or amendment to a contract. Currently, only the state auditor and JLAC have the authority to view these contracts prior to becoming public 3 years after the contract has been in place. Prison health care costs, as everybody knows, currently are skyrocketing. The nonpartisan, LAO, found dramatic increase in spending on adult prison health care from $1.2 billion in 05-06 to $2.5 billion in 08-09. Last year, California spent on average a little over $16,000 per inmate, $170,000 total for health care services. The LAO directly attributes the growing health care costs to greater usage of contract medical services. Despite the growing costs in prison health care, the LAO and members of the legislature who are not members of the Joint Legislative Audit Committee are kept in the dark about exactly how much is being spent on these health contracts. And I found this particular part to be interesting, and it was really the genesis behind the bill. For these health contracts, even if you are the esteemed chair of the Budget Committee or the subcommittee that oversees the prison CDC and the prison contracts, you are not given this information. And so this bill simply, Madam Chair, attempts to accomplish that, and I respectfully ask for your aye vote.
Thank you, Senator. Any witnesses in support?
There was someone here. They had to leave early because time ran out.
I'm sorry. I apologize. Witnesses in opposition? Go ahead.
Afternoon, Madam Chair, members. Dan Chick with HealthNet. We're in opposition to the SB 484. We think that it could have an unintended consequence of hampering the ability of the state to achieve cost savings in the provision of health care services to prison inmates. By way of quick background, HealthNet entered into a contract with the Receiver's Office last year to build contract networks at a lower possible rate to provide services to inmates for care outside the prison walls. We do this by repricing existing contracts at the lower rate that we were able to negotiate, utilizing our networks and bringing in new providers into the networks. By doing so, we've been able to reduce costs and expand the networks available to prisoners outside the prison walls. As the Senator mentioned in his opening, under current law, which is modeled after laws that affect Medi-Cal, Healthy Families, and I believe CMAQ, these rates are kept confidential for 1 year, and from 1 year to 3 years, the contract can be open to some inspection, but what can't be revealed is the actual contract rates in which we're negotiating. This has been in law for a long-standing period of time, and it serves state health programs rather well. HealthNet also provides Medi-Cal services to about 1.1 million Californians, and I can tell you that the ability to negotiate these contracts in relative confidentiality so that others bidding for the contract or negotiating for contract services to provide for the enrollees, if that information is in any way public, it compromises the ability to get the lower rates. This bill would expand the list of individuals that could receive the contract to all 120 legislators and their staffs. We do have some concerns there. For instance, would the legislators and their staffs be aware of the existing prohibition on disclosure for 3 years? Obviously, this is information that when we go out to negotiate with hospitals and provider groups, that would be the kind of information I would certainly like to know. And in HealthNet's case, when we negotiate for Medi-Cal members, for instance, that's information I would certainly love to know is what my competitors are paying other providers. So for these reasons, we have concerns with the bill, and we would ask for a no vote.
I would like to ask you a question, though, before you leave. How is the legislature, or even the folks that are allowed under current law to look at these contracts, how are we to know whether we are, in fact, getting lower rates? And how can we compare that to anything to determine, because lower is a relative term, right?
Correct.
So how can we compare to make sure that the rates are, in fact, lower and are, in fact, competitive? I mean, I'm totally in the dark about this at this point because I'm not allowed to see the contract.
Sure.
So how does that actually lead to lower rates? How do we know that?
Well, I think in this case, you're relying upon the ability, in this case, the receiver's office to and I know specifically our contract. I understand what you're getting at, but under our contract, we know what the rates were before. We're out there trying to reprice them lower in order to get cost savings. And in this instance, you have the backstop of JLAC and the state auditor. If in any situation there might be, some concern about the contract, I think that the state auditor could review the contract and while at the same time protecting the confidentiality of those rates.
But they could review it, but they can't talk about it. So
well, they
there
could
can't
make
be
findings.
A public report.
Yeah.
Okay. You're from the receiver's office.
Hi.
So
Yes.
Go ahead.
Joyce Hayhoe, Director of Legislation for California Prison Health Care Services. First of all, I'd like to say to the committee that we have not taken a position on this bill. So we are here to talk about the public policy surrounding disclosure of information. So the one question that you have, Senator Evans, is a good question. That came up recently at a hearing that we had in front of the Assembly Accountability Committee hearing. They asked that question of the Bureau of State Audits. And what the Bureau of State Audits was able to tell the legislators is that within their work, they would be able to take a contract with the information provided to them, unredacted, compare it to any kind of other contract that California Prison Health Care Services had entered into, and then could report out to the public, to the committee, whoever, whether or not that was a good value for the state of California. So that's how they would do it without being able to disclose rates. They would be able to say whether the state had a good deal, got a good deal, or got not so good of a deal. So that's how they would do it.
Okay.
So in terms of another thing that I just wanted to point out to the committee, as you consider the public policy of how to have disclosure laws in the government code, is that our code section that covers disclosure for California Prison Health Care Services and the Department of Corrections and Rehabilitation is separate and apart from the government code that discloses, that governs the disclosure for all other state agencies doing medical contracts such as the Medi-Cal Healthy Families, which was mentioned. We would just let the committee consider that as you set policy for who should have the ability to see contracts disclosed, you probably would want to consider that for all other state agencies, so you just have a level playing field.
Okay, thank you. Yes, Mr. Harmon?
Thank you, Madam Chair. I had a question for Mr. Chick, if I could. What legal remedy would a contractor have if the confidentiality of the contract was breached by, say, for instance, a legislative staff member? What can you do?
I don't know that we would have a recourse. I don't know that our contract contains any provision that would allow us to be, excused from that contract. Certainly, in our respect, it would inhibit our ability to get the kind of savings I think the state's looking for. But I wouldn't know what our recourse would be. I don't know that I don't think we have one.
And maybe a slightly different question, but do we have a problem here? Is the thing I'm wondering about. Why do we need these additional disclosures? They're already, disclosed to current members of JLAC. Maybe I should address that to you, Senator Rubio.
Well, thank you, Senator
What's
Harmon.
the problem?
The problem is the rising increased costs related to delivering health care for our inmates. And I, quite frankly, view it as government always works better when you have more oversight, more accountability. And this bill is very simple. It tries to take this information and put it in the hands of members of the legislature who are making decisions as it relates to the budget every single day. And so quite frankly, I see it as a measure to bring more accountability, more oversight to an area in state government that we are experiencing significant increases in costs. That's one. Second, I would say that everyone who receives this information within the 3-year time period will be required under the same confidentiality laws as members of JLAC today. So you don't see that information being leaked today. So I don't see the concern in providing it today.
If JLAC already receives this information, can't they and wouldn't you expect them to pass it on to appropriate, people involved with the budget?
No, I wouldn't expect them to do it.
If they thought it was appropriate?
I happen to sit on JLAC.
I know you do.
And I actually staffed it at one time as well, and I've never found it to be the case where we would take information and then provide it, say, in the middle of budget conference hearings or subcommittee hearings. I think what I'm trying to accomplish with this bill would be to provide the information that is necessary, the information that would be helpful for all members of the legislature, whether you sit on a subcommittee or the full budget committee, to be able to make a decision on what's right for the fiscal whereabout of the state.
If that information is disseminated somewhat broadly, then wouldn't that affect the contractual rights of the people that are involved in the contract, bid prices, things like that?
I don't believe so, because if the members of the legislature keep it confidential, which they will be required to do so, it's no different than what members of JLAC are receiving today. This bill simply tries to make it easier so that we can, as members of the legislature, have the information readily available to do two things. One, to try to reverse the trend of the increasing costs we're experiencing today in California. But second is to verify. Ronald Reagan's old saying, trust but verify, with all due respect, when we are told that we're going to see savings, we're going to see greater utilization, we're going to see a reduction in costs, we have to wait 3 years before we can actually confirm any of that if you are a member of the legislature and you do not sit on JLAC. And so I think by passing this bill today, Senator Harman, we'll have that information available and be able to make that decision for our respective districts without having to jump through the hoops of petitioning to JLAC to get the information.
All right. Thank you very much.
Thank you. Any other witnesses in opposition? Thank you. All right. Seeing none, we have a motion, and I'm just going to express a slightly different level of frustration that I have. I like the bill, but I don't believe it goes far enough. I understand this is one of those gray areas where there are certain things perhaps necessary to protect as far as the providers of services, but it's in the public's interest to know, and greater transparency and accountability is always in the public's best interest. So to allow legislators who are here in the Senate representing nearly 1 million people each to review the information and then muzzle them and not allow them to speak about it means that we can know about something that is negative, perhaps and not in the public's best interest, but we can do nothing about it. And so I like the bill, but I believe it only goes halfway. And like I said, I understand that there is an argument to be made that there is a certain level of confidentiality that is necessary for some reasons. But I'm not, with this bill before me, I'm not allowed to weigh those relative interests. However, having said that, I will support the bill because I believe it is a good step in the right direction. But my preference would be to allow legislators to actually do something about the information that they find out, if it merits it.
And Madam Chair, as this bill moves through the process, should it be able to get out of this committee this afternoon, I'd love to work with you and your staff to accomplish the entire task.
Sounds good. Thank you. We have a motion to pass the bill out of committee. Call the roll.
The motion is to pass to Senate Public Safety. Evans?
Aye.
Evans, aye. Harman? No. Harman, no. Blakesley? Blakesley, no. Corbett? Leno?
Aye.
Leno, aye.
The vote is 2-2, and we do have an absent member, so the bill will remain on call. Thank you. Now I want to let everybody know that we do have a special order of business at 3 o'clock. Before we get to that, though, I also want to note that after that special order of business, the committee will take up the vote-only items that were left from last week's committee hearing, as well as my bill, SB 299, and then the consent calendar. So, Mr. Leno, we are now calling our special order of business SB number 48, item number 1. And for the public who is here on this bill and for the committee members, I want to let you know that we had scheduled 45 minutes to take up this bill. I will extend it, if necessary, to an hour. So we've set aside between it's now 3:05, so till 4:05. And the way I've structured our time is to allow Senator Leno 5 minutes for his opening and then 20 minutes for supporting witnesses. So, and 20 minutes for opposing witnesses. The committee staff has done their best to get in touch with the folks who have submitted voluminous correspondence both for and against the bill so that they would be advised of the order of business. So hopefully everybody's gotten word and you have structured your testimony accordingly. And then we will allow 10 minutes for questions and comments by the committee members and close by Mr. Leno. And I can see, looks like the number of witnesses that we have for and against can be easily accommodated within that time. So, great. Senator Leno, you may begin.
Thank you, Madam Chair, for the opportunity to present our bill, SB 48, but also for your generosity of time and interest in this issue to have this 45 minutes to an hour so we can have a very inclusive and comprehensive debate. The very fundamental point of the bill is that all students deserve a safe, supportive, and validating space to learn and to grow, and that would be all students. So the Fair, Accurate, Inclusive, and Respectful Education Act will ensure that lesbian, gay, bisexual, transgender students, Americans, as well as persons with disabilities, are included and recognized for their important historical contributions to the economic, political, and social development of California. We already have a long list of those groups which are traditionally overlooked who are afforded this inclusion. It specifically is about including the role and contributions of these LGBT Americans and their role in the history of California. And this is all in the context of a very serious phenomenon that we see in our schools right now, which is bullying and social isolation. And the pain is real that students experience. You'll hear from some students today. And we know that when students are ostracized, when they are harassed, when they are verbally, emotionally, and at times physically abused at school, they're going to be disengaged from their studies. And it is our responsibility to make sure that every student has the right to their public education. We also know that when students are disengaged from their studies, they're more likely to fail, they're more likely to drop out, and if a student drops out of school before obtaining his or her high school diploma, he or she has a 7 times greater likelihood of finding his or her way into our criminal justice system. So this is really also about safer communities, making sure we have productive citizens who have been appropriately educated. I just want to give some examples. If students who, of course, due to the lack of information they're getting right now, are less familiar with LGBT Americans, they're more likely to fear them and to dislike them. So if they learn that what we're really talking about here is a civil rights movement that has been unfolding in modern day since the Stonewall riots of 1969, to understand what led up to those riots in 1969, that there was serious discrimination, that not long after the Stonewall riots, that the American Psychiatric Association finally dropped from its list of mental illnesses homosexuality. And not long after that, LGBT people openly ran for office and were elected, not unlike Elaine Noble, who was the first person in the country, assemblywoman from the state of Massachusetts, and of course right here in California, the very first person to be elected as an openly LGBT person, Harvey Milk, and the fact that he was assassinated by a fellow colleague because of who he was. This is important information for students to understand. And not long after that, California and other states dropped their laws which made it a felony for consensual adults of the same sex to have relations. And that now we have Senator Kehoe's bill, which was before us today, that by 1999, California made it illegal to discriminate in housing and employment on the basis of sexual orientation. And a few years later, we added gender and gender identity. So this is the arc of justice that Martin Luther King makes reference to. And I was asked by a reporter recently, why should what one does in one's bedroom determine whether or not one will be included in a school textbook? And I said, let me ask you a question in return. Why should what I do in my bedroom determine whether or not there will be governmental discrimination against me and the certainty of my second-class citizenship in this country? To date, federally, there are still no protections from discrimination in employment, housing, public accommodation based on sexual orientation or gender identity or expression. I still can't marry the person whom I love. And until very recently, I could not openly and honestly serve my country in the military. No other minority group in this country is treated in such a second-class fashion. So I just want to point out, our adversaries can't have it both ways. If you want to tomorrow elevate me as a result of my sexual orientation to a first-class citizen, well, then I might think of dropping the bill, and there may be much less need for it. Isn't it tragic irony that a man named Bayard Rustin organized the very famous Martin Luther King March on Washington rally, where he gave his now very famous I Have a Dream speech? Bayard Rustin was a gay man who, because of the times, this is in the early 60s, had to be closeted even in his struggle for a civil rights movement for African Americans and other minorities of color. This is important information for students to know, and they would also learn the definition of tragic irony. So I would make the argument that better educated students make better educated citizens, and that by teaching children the history of discrimination and the battles that are fought to overcome it, as we attempt to fulfill the great promise of our democracy that, yes, all men and all women are created equal and are deserved equal protection under the law, that we appeal to students' higher selves. And wouldn't that be great for all of us? So I would ask for your aye vote. I may ask for just a couple minutes at the end. This is our second policy committee. I'm familiar with some of the arguments that the opposition will bring forward, and some of them are just inaccurate, and I'd like to be able to correct them if that is the case. So again, I thank you very much. We have a number of folks here, including our sponsors. Carolyn Loeb is here from the Gay Straight Alliance Network, and then followed by the California Equality California, excuse me.
Thank you.
And Mario will speak for Equality California.
I want to make sure that I give the same amount of time to both the proponents and the opponents of the bill. So I've allocated 20 minutes. And I will do the same for the opponents because you're going first. So you have to trust that I'm going to give 20 minutes to you and 20 minutes to the opponents. So go right ahead.
Good afternoon, Madam Chair, members of the committee. My name is Mario Guerrero, and I'm here on behalf of Equality California. Equality California is a sponsor of SB 48, the Fair, Accurate, Inclusive, and Respectful Education Act, authored by Senator Mark Leno, and we thank the Senator for his leadership on this bill. The Fair Education Act would bring classroom instruction into alignment with the existing non-discrimination laws in California. This bill would simply add the contributions of lesbian, gay, bisexual, and transgender people to instructional materials, much as we do for an existing list of underrepresented cultural and ethnic groups already covered by current law. The opposition is painting the Fair Education Act as a request for special treatment or special rights, which is blatantly false. This legislation simply calls for accurate and inclusive history to be taught in our schools. The negative views of an individual or a group on a particular minority, in this case LGBT people, should not be the reason that an entire civil rights movement, in this case the LGBT civil rights movement, should be treated as non-existent. The opposition seems intent also on describing this bill as a measure that would teach kids about sex. Again, this is simply untrue. They also believe that hearing the words gay or lesbian are going to somehow make students gay or lesbian. I'm here to tell you that kids already hear the word gay and lesbian in their schools every day. Some kids hear these words as they are being picked on and bullied. The Fair Education Act does not introduce new subject matter. It simply introduces the subject matter in a respectful and accurate way. In fact, we know that the inclusion of LGBT people in instructional materials is linked to greater student safety and lower rates of bullying. In closing, I hope that those who oppose this bill today do so in a respectful manner that does not malign LGBT people by insinuating that we are mentally ill, confused, or disrespect transgender people based on their gender identity or gender expression. I respectfully ask for your aye vote. Thank you.
Good afternoon. I'm Carolyn Laub, Executive Director of Gay Straight Alliance Network, another co-sponsor of the Fair Education Act. Bullying of lesbian, gay, bisexual, and transgender youth is still a pervasive problem in our schools with serious consequences on students' mental health and academic achievement. GSA Network hears stories every day from our student members who are called names, pushed, shoved, spat upon, and physically assaulted because of their sexual orientation or gender identity or expression. Our research with the California Safe Schools Coalition found that rates of bullying based on sexual orientation and gender identity are reduced by more than half in schools where students learn about LGBT people in the classroom. The inclusion of LGBT people in classroom discussions can make LGBT students feel less alone or isolated, improving their ability to learn, stay in school, and graduate. Fair and accurate depictions of LGBT Americans in classroom materials will teach all students to respect each other's differences, increasing safety for all students. If we want communities that are respectful of differences, then our schools need to model that. That's why I urge your aye vote on the Fair Education Act. Thank you.
Good afternoon. My name is Isaiah Biceri. I'm a senior at Glendora High School. As a gay young man, I struggled with accepting my identity for years. The world had taught me that gay people aren't successful. They haven't achieved great things like leading movements, inspiring minds, and making the world a better place for all. Or have they? I came out as a sophomore. I had known I was gay for about 5 years before doing so, but I struggled day in and day out because I was afraid I'd be stereotyped into the image of a typical gay man so often the media perpetuates. Little did I know I could follow in the footsteps of amazing individuals who also identified as gay and definitely did not fit into the narrow stereotype I had known my whole life, the same stereotype that kept me in the closet. With the Fair Education Act in place, I would have grown up knowing I could be successful and proud of who I am. I would not have had to lie to the world and hide my identity each day, living each day wondering if I belonged in a world where I didn't fit in. Where was my history when I needed it?
Thank you for permitting me to speak today in favor of SB 48. My name is Dr. Robert J. Green, and I'm officially speaking on behalf of the California Psychological Association. My professional title is Distinguished Professor of Psychology at the California School of Professional Psychology at Alliant International University, which is California's largest nonprofit educational institution for doctoral-level psychologists. As a professor of psychology, it is my professional view that mandating school curricula to be inclusive of the many historical and social contributions of the LGBT community is critical public policy. Such inclusion is essential to address the epidemic of bullying, as well as to support stable, confident self-identities for thousands of youth who perceive themselves to be different in some way from their peers, whether they identify as LGBT or not. In fact, you may not know this, but a very significant proportion of the kids who are harassed as being LGBT are in fact heterosexual. And if you have sons in schools, you know exactly what I'm talking about. Individually oriented programs of counseling or adjudication of bullies are in themselves not sufficient to reduce the bullying towards LGBT students or those who are otherwise perceived to be different. Children, including teenagers, take their cues from adults, including their teachers. Silence about LGBT figures in the social studies history curriculum implicitly renders LGBT youth invisible, sending the message that LGBT people must hide because their existence is too shameful or too controversial to be openly acknowledged. This silence is harmful to the emotional development of all youth who are perceived to be different, whether they self-identify as LGBT or not. Overall, this silence teaches all youth to fear their own characteristics that might make them slightly different, and supports others' aggressive, hurtful actions that seek to suppress or silence these characteristics at school and in the society at large. I urge you to enact SB 48 not as a cure-all for bullying, but as one part of a larger effort to make California schools safer for LGBT youths and for the heterosexual youths, many of whom are also bullied because they are perceived as being gay. This legislation will reduce school absenteeism, dropping out, depression, and suicides in response to bullying. I believe SB 48 will contribute to the saving of many LGBT youth's lives and will inspire many others to greater achievements. Lastly, as a professor of psychology, I want to emphasize that when school curriculum recognizes important contributions of groups of people who have historically been shunned or silenced, it supports and strengthens the psychological well-being of all children, encourages them to respect and appreciate the differences of those around them. This creates an enhanced opportunity for all youth to focus on learning at school and encourages healthy self-confidence and self-esteem. With SB 48, as our youth enter adulthood, they will be better prepared to make positive contributions to society and to live meaningful, happy lives. Thank you.
My name is Lisa Berry, and I have known the dark heartache of death because it gave birth to my organization when my youngest son, Michael, became a victim of a peer abuse-driven bullycide. Michael shot himself on his 17th birthday at Mariloma High School. As a grieving parent, I know the horrible heartache of bullycide. I know the looks, I know the stares, I know the whispers, I know the pain. I know people wonder how something like this could happen in their community, in their school. I know I wonder how something like this could have happened in my family, to my son. As a matter of fact, I still wonder as I grieve my son's death 2.5 years after his bullycide. Michael was a well-loved young man, and unbeknownst to us, Michael had come under attack by a well-known abuser whose sense of humor was that of a sociopath. Our son's abuser had a behavioral file a mile wide, and this young man sat behind our son in his 4th period class and tormented him unmercifully. Unbeknownst to us, this abuser had set his sights on our son. Michael's abuser proceeded to text, tell, shout from the rooftops via MySpace and email that Michael was gay, while calling him every vile name in the book. When I think about how we use language to hurt, to abuse, to create harm, it hurts me on such a deep level. I love the beauty of language, the written word, the spoken word, the lyrical quality of a well-stated argument, the grace of a beautifully written poem, or the power and passion of a book that conveys the meaning of life because one's soul gave birth to the words that gave birth to the artistry. Words have great power. Both the verbal and written word have the ability to change the course of history, the meaning of life. Both can soothe, both can heal, and sadly, both can destroy. However, it's when our actions become louder than our words that we need to stop and reconsider the type of people we are becoming. Yes, actions speak louder than words, but in the end, words have a far greater power than the action that directs them. I want our communities firmly dealing with peer abuse. I want people outraged over the abuse of our children. It is my belief that outrage can move mountains, which is why I support SB 48, because I agree with Senator Leno that the exclusion of LGBT Americans spreads negative stereotypes in school activities, therefore sustaining an environment of discrimination and bias in schools throughout California. Our children come into this world as blank slates with pure spirits and pure hearts. They come to us free of hate, free of judgment, free of bias. They come to us as gifts, and no one has the right to take the gift of their childhood away from them. Not their peers, not their parents, not their teachers, and not their communities. Children are not born hating, hurting, harassing, or intimidating. As a society, we have deemed these behaviors unacceptable, and yet they persist. Imagine if we taught our children with the same zest, pride, and passion across all school curriculum. We have an amazing opportunity with FAIR to teach our children that people contribute in many different ways. We are their role models and must seize control of our peer abuse situation because it is spiraling out of control. We must utilize our teachable moments and lead by example in order to show our children the consequences of abusing each other. When I speak to people about peer abuse and I can see the questioning looks on their faces, I'm often reminded of what Gandhi said in light of his own pain and struggles. Be the change that you want to see. With that being said, I continue to imagine a world where we are all equal and protected. I believe our children have a right to a fair, accurate, inclusive, and respectful education, one free of peer abuse. Thank you.
I am so sorry for the loss of your son.
Thank you.
Go ahead.
Madam Chair and members of the committee, thank you for this opportunity to speak in support of SB 48. I'm the Reverend Dr. Rick Schlosser, Executive Director of the California Council of Churches and Church Impact. We have directly 1.5 million members throughout California, and our 21 member denominations have over 6.5 million members in the state. Every faith tradition teaches that every society will be judged by how it treats the most vulnerable citizens. And because of the lack of positive role models, we see far too much bullying and even suicides among our LGBT youth, and even those who are only perceived to be gay due to prejudice and lack of knowledge. This legislation can help people understand differences and live together in peace and with respect for one another. Teaching about the contributions of the LGBT community is not and should not be a problem for people of faith. As a matter of fact, for many people of faith, it's a matter of religious freedom that all people, including LGBT people, are included. You'll hear from the opposition that SB 48 will curtail their freedom of religion, but in fact, the only thing curtailed by this legislation is the freedom to discriminate, bully, and create unsafe environments for our youth. We have a long history in California of acknowledging the contributions of many groups who have contributed to making California the diverse society it is today. It's unfair to discriminate against any one group by attempting to impose one narrow religious perspective on the rest of us, whose faith perspective calls us to celebrate the diversity of humanity that was created and blessed by God. We strongly urge you each to vote yes on SB 48. Thank you.
Next witness.
I'm Charles Wibbelsman. I'm a pediatrician in adolescent medicine. I'm a fellow of the American Academy of Pediatrics. I'm here for the CMA, and I wanted to speak from my heart as a pediatrician why I support this Assembly Bill, Senate Bill 48. As you may know, any of us who take care of teenagers, 250,000 attempts, suicide attempts every year among adolescents. 5,000 are completed suicides among teenagers every year. 1/3 of all male adolescent suicides are related to sexual orientation. And so much of this is related to bullying and discrimination in the school. If you know about the story of the Rutgers student in October who was filmed in the dorm room and then jumped off the bridge to kill himself because of bullying and pressure, it's enough for us to realize that these kids need a positive role model, somebody that they can look up to. And if the history books would allow someone like Harvey Milk to be in the history book, then we would maybe not have these children and adolescents depressed and committing suicide. And a final note, I should let you know, as a pediatrician in San Francisco, 3 years ago, I had 3 of my patients. All were white. All were 17. One jumped off the Golden Gate Bridge. One hung himself, and the other one jumped out of the window. And it was because of suicide related to sexual discrimination and peer pressure and bullying. So I support Senate Bill 48 and I hope that you will remember these thoughts. Thank you.
Hi, my name is Benji Delgadillo. I am a 16-year-old openly transgender student from San Juan Hills High School. In my social science classes, we aren't given any fair or accurate information about LGBT people. And this frustrates me because I feel as if my school is discounting a community of people that I strongly identify with. This causes me to feel as if my school pretends that we don't exist or are something to be covered up and not mentioned. I know that there is a rich, beautiful history of my community, particularly around the LGBT civil rights movement. With the lack of representation of LGBT people in social sciences, students are not aware of the contributions that LGBT people have made to American history. At my school, there is still a lot of negative treatment of students like me because peers are not learning about LGBT people in history. They are only hearing stereotypes. But if students were taught in a fair and accurate way about LGBT people in history, it would alleviate misconceptions and students would realize that being LGBT is not something that students should be bullied or harassed for. All students, not just transgender students like me, deserve the right to be included in our education. So I urge you to vote in favor of SB 48, the Fair Education Act.
Before we get to the next witness, sorry, I'm just keeping an eye on the time, and I see we have 5 more witnesses here. Are there other witnesses in support waiting to testify? Oh, my. Okay, and how many witnesses in opposition to the bill? Could you raise your hand? Okay. If I let everybody speak for even 2 or 3 minutes, we will be here over an hour just for the remaining proponents.
Me Too's are okay.
Me Too's are okay, yes.
If we're running up against our time.
Yeah, but I do want to be respectful, though, and I'm
right.
finding the testimony, the individual stories in particular, very interesting. I'm sure that we'll hear many interesting comments from the opposition as well. So I want to be respectful of everybody's time, though. And if we spend another hour here with the proponents of the bill, it would be another hour and a half for the opponents, and we still have a great deal of business to transact for the remainder of the agenda. So I don't want to cut you off, but I do want to strongly encourage you to simply state your name and affiliation and Me Too at this point.
Isabel Garcia, on behalf of the California Teachers Association, we ask for your strong support for this landmark bill that promotes safe teaching and learning environment, as well as promoting respect for diversity in our schools. Thank you.
Thank you. And when you finish your testimony, if you could stand up and let the next witnesses come and take your seat, I'd appreciate it. Yes, ma'am.
My name is Natalie Thorson. I provide professional development training for California teachers. One of the constant challenges that teachers encounter is how to support all students in an increasingly pluralistic society where marginalization and dehumanization are quickly becoming the standard. One of the things that teachers say that they need, that they want this, they need this, they just want historically accurate information that includes the contributions of all people. I encourage you to support SB 48.
Thank you. Yes, ma'am.
My name's Adam Price. I attend Redlands High School in San Bernardino County, and I strongly suggest you support this bill because I think that I've been bullied due to the lack of information that's been put in textbooks about the great contributions that have been made to the LGBT community. Thank you. Have a great day.
Hi, my name is Tara Fleming, and I am a parent of a young child in public schools. I'm straight, and this is important because my child, if he does not get this information, not only could he risk becoming a bully, but he could be bullied. There are 2 parts to this. He is already becoming what I see as a straight white male. If he does not get this information, he could be one of the perpetrators. This is so important. Please consider the lives of young children in this state.
Thank you.
My name is Buddy Sims. I'm from Pomona. I implore you to please vote yes in support of the Fair Education Act so all students will see themselves reflected in history. Thank you.
Thank you. And other witnesses, I'd encourage you to come and take the empty seats, please. Yes, sir.
Good afternoon. My name is Sean Cahill. I'm here today with my family, my partner Carrie Kelly, my 2 children Ryan and Justin. We're here to strongly support SB 48. We need this in our schools. We need this for our children. Thank you.
Thanks. Thanks for being here.
Hello, my name is Ajane Lawson. I'm a senior at Hiram Johnson High School in Sacramento. I support SB 48 because I feel that LGBT minorities, as well as any other minority, needs to be represented in our school instructional material. Thank you.
Thank you.
Good afternoon, Madam Chair, members of the committee. I'm Santosh Siram Santana with Asian Americans for Civil Rights and Equality. We are a joint partnership of 3 Asian American civil rights organizations, which are the Asian Law Caucus, the Asian Pacific American Legal Center, and Chinese for Affirmative Action, and we are in strong support of this bill. Thank you.
Steve Skiffington. I'm a member of Trinity Episcopal Cathedral, a member of Integrity National. Just want to remind you the quickest way to diminish someone is to make them invisible. Please do not make our people invisible. Thank you.
Thank you.
Madam Chair, members of the committee, Virginia Strom Martin on behalf of Los Angeles Unified School District. We're in strong support of the bill. We have instituted our own inclusive curriculum since 2007, and we are finding that it already has very positive impacts in terms of more acceptance of differences and safer school campuses. So we enthusiastically support the bill. Thanks.
Thank you.
Good afternoon. I'm Dave Reynolds with the Trevor Project, and we fully believe that the Fair Education Act will improve school climate and safety for all California students, reducing the fiscal and emotional costs associated with bullying, harassment, intimidation, and the negative psychological outcomes, including suicide, that come from there. So we urge an aye vote on SB 48, please.
Thanks.
Madam Chair, Chair people, my name is Dee Hamby. We're a National Organization of Women, California, and we're in strong support of SB 48.
Thank you.
Good afternoon. I'm Judy Appel, and I'm the Executive Director of Our Family Coalition. We are an organization working to serve the healthy families in the San Francisco Bay Area. I'm also the mother of 2 children, both 13 and 10, and on behalf of our organization, our members, and my family, I urge you to vote aye on SB 48.
Thank you. At the podium.
Hi, my name is Wendy Mustaine, and I'm a member of Trinity Cathedral, and I wanted to share this very short quote from Desmond Tutu. "Differences are not intended to separate or alienate. We are different precisely in order to realize our need of one another." I hope you will support the bill.
Now it's your turn.
Brandon Tartaglia with Disability Rights California in strong support.
Thank you.
Catherine Valenzuela with Public Advocates in strong support of the bill.
Rebecca Gonzalez, National Association of Social Workers, California chapter, also in support.
Randy Hicks of California's Disability Rights. The only thing I want to say is that as a member of the disability community, he should also be recognized for his contribution. His bill does that, and as a gay man, it does that too. So we're in strong support.
Khadija Alam Javed with the Advancement Project. We're a public policy change organization rooted in the civil rights movement. We thank Senator Leonard for his leadership on this issue, and we ask for your support.
My name is John Viet from Our Family Coalition, and as a student of the California public school system, I was bullied a lot, and I think this bill would really help prevent that. And strong support. Thank you.
Thank you.
Mason Davis from the Transgender Law Center. Please vote aye on this bill. Our youth need to know that they have a history and a future. Thanks.
Good afternoon. My name is Glenn Backus. My daughters asked me to testify on behalf of my wife and my two school-age daughters in support.
Thank you.
Beth McGovern on behalf of the California Commission on the Status of Women in strong support.
Mary Helen Doherty. I serve on the LGBT Task Force for Sac Unified School District, and on that behalf I represent the progressive faith community that supports our LGBT community, and we ask that you respect the inherent worth and dignity of all members of our community. Please support. Thank you.
Madam Chair, members, Helene Mesha representing the City of West Hollywood in support. We feel that SB 48 will promote an atmosphere of safety and respect for all students in all of California schools. Thank you.
Amanda Levy on behalf of the California Psychological Association. You heard from Dr. Green. Just wanted to testify that our 5,000 members are in support.
Great. Thank you. Other witnesses in support of the bill? Okay. Then we will have the opposition witnesses come forward, please, those opposing the bill, and I gave an additional 5 minutes to the proponent witnesses, and so I will give the same accommodation to the opponents, and I will keep an eye on the clock so that when we get to the point where we're getting close to running out of time, I'll let the remaining witnesses know, and just to state their name and affiliation and their opposition to the bill. And again, as you finish, if you would leave the seats and allow additional witnesses to come and take your seats, I'd appreciate it. All right. Who is the first witness in opposition of the bill?
Madam Chairman and members of the committee, my name is Kevin Snyder, and I serve as Chief Counsel for the Pacific Justice Institute. This afternoon, I would like to bring to your attention language within the bill, which is legally problematic. The terms that raise legal difficulties are promote a discriminatory bias and reflect adversely. Within the last several years, I have represented professors at California community colleges who have been disciplined, and one was fired because they unwittingly transgressed similar vague restrictions and instruction. In one instance, the professor taught a biology course in human heredity. She was asked by a student whether homosexuality was genetic. The professor said that the issue was complicated, cited a German study which found a correlation between maternal stress, maternal androgens, and male homosexual orientation at birth. The study found no correlation, the professor continued, between maternal stress and the phenomenon of female homosexuality, and then referred to chapters that the class would be reading in the weeks ahead. For this answer, the professor of more than 20 years was fired. A lawsuit was filed in federal court, and after much expensive litigation, there was a significant